Have you ever wondered what really happens inside a courtroom during a major criminal trial? It can seem pretty complicated, right? Well, today we're going to pull back the curtain. We're going to follow the entire journey of a case, from the very first accusation all the way to the final verdict. We're turning a complex legal process into a clear story.
So, this is the big question we're tackling. We're literally going to map out the entire legal path, from start to finish. By the end of this, you'll have a crystal clear understanding of how the system works, every single step of the way. All right, here's our roadmap. We've broken this journey down into 5 key stages. We'll start with the basics, how a case even gets to a sessions court. Then we hit a major fork in the road. After that, we watch the prosecution and the defense battle it out, which all leads up to the grand finale, the closing arguments and the judge's final decision. Okay, let's dive right in. Before any trial can really get going, you have to set the stage. So first things first, why are we in a sessions court? And how does this whole process officially kick off? A sessions court is where the most serious criminal cases are handled. We're talking offenses that could lead to life in prison or even the death penalty. But here's the thing, and it's super important. A case doesn't just start here. It's first looked at by a magistrate's court. Only if that lower court feels the case is serious enough does it get formally committed, or, passed up to the sessions court. That's all laid out in Section 213. It's like a critical filter. So once the case lands in the sessions court, the curtain rises on the trial. And the first person to take the stage is the public prosecutor. Under Section 248, they represent the state. Then, under Section 249, they deliver their opening statement. Honestly, you can think of it like a movie trailer. They lay out exactly what the accused is charged with and give everyone a roadmap of the evidence they're going to use to prove it. And that opening statement, it leads us straight to the first critical turning point in our whole journey. After hearing the prosecutor and looking at all the initial paperwork, the judge has to make a huge decision, one that decides the immediate fate of the entire case. This is it. This is the fundamental question the judge is wrestling with right now. They've seen the police report, they've heard the opening pitch, and now they have to ask themselves, is there actually enough substance here to justify going through a full-blown trial? And that question leads to a massive fork in the road. On one hand, if the judge looks at everything and decides there are no sufficient grounds to move forward, they'll issue a discharge under Section 250. Boom, case over, accused walks free. But if the judge thinks there's at least a presumption that an offense was committed, they will frame the charge under Section 251. And that is the official green light. The trial is on. So what exactly is the judge looking for here? This principle from a really famous case nails it. At this stage, the judge isn't trying to figure out if the accused is guilty. Not at all. They're just looking for what's called a prima facie case. The best way to think about it is there enough smoke to suggest there might be a fire? If so, then it's worth investigating with a full trial. That's the test. And the law wants things to move quickly. Once that decision is made to frame charges, Section 251 says those charges have to be put in writing within 60 days of the first hearing. The clock is officially ticking. All right, let's move on. The charges are framed, and now the burden of proof lands squarely on the shoulders of the prosecution. They made the accusation, and now it's up to them to prove it beyond a reasonable doubt. Okay, so the trial now gets very formal. First, the charges are read out loud to the accused. They then have to enter a plea, guilty or not guilty. Now, if they plead guilty, and it's a clear, straightforward plea, Section 252 says the judge can convict them right then and there. But if they plead not guilty, or just refuse to plead, then under Section 253, the court sets a date for the main event to begin, the presentation of the prosecution's evidence. So now, as per Section 254, the prosecution starts building its case. They call their witnesses, they submit documents, they present every piece of evidence they have. It's interesting to note that the law even allows for testimony to be recorded using audiovisual tech. The judge's job here is to basically act as a referee, making sure everything is fair and the process is followed correctly. Okay, the prosecution has laid all its cards on the table. And now the spotlight swings dramatically over to the other side. It's time for the accused to respond to the case that's been built against them. But hang on a second. Before the defense even starts, there's another massive checkpoint. After the prosecution is completely done, the judge takes a hard look at everything that was presented. And if the judge thinks, you know what, there's just no evidence here, they don't even need to hear the defense's side. Under Section 255, they can acquit the accused right there. It's a really powerful safeguard against weak prosecutions. Now, if the judge believes the prosecution has made a strong enough case that requires an answer, well, then the trial moves forward, and the accused is formally called upon to present their defense, a right they have under Section 256. So, what's in the defense's playbook? A lot, actually. They can submit their own side of the story in writing. They can call their own witnesses to the stand and present their own evidence. And here's a big one. They can ask the court to issue a summons, that's a legal order, to force a witness to show up or to get a specific document. And the court has to do it, unless the request is obviously just a tactic to waste time or mess up the trial.
And that brings us to the grand finale. All the evidence from both sides is in. All the witnesses have spoken. Now it's time for the lawyers to make their final pitch and for the judge to deliver the ultimate verdict.
The end of the trial follows 3 key steps, laid out in Sections 257 and 258. First, we have the closing arguments. This is the last chance for the lawyers to convince the judge. The prosecution goes first, but the defense always gets the final word. Then comes the moment of truth, the judgment. But if the verdict is guilty, it's not quite over. There's a separate special hearing just on the sentence, giving the accused one last chance to be heard before their punishment is decided.
And you guessed it, there's another deadline to keep things moving. The judgment is supposed to be delivered within 30 days of the final arguments. It can be stretched to 45 days, but the judge has to write down the reasons why. So after this entire legal marathon, it all comes down to one of 2 outcomes. An acquittal. The accused is found not guilty and they walk free. The ordeal is over. Or a conviction. The accused is found guilty and the final step is for the judge to decide on the sentence.
Now, there's one last really crucial rule of fairness we have to talk about. It's in Section 259. What if the person on trial has a criminal record? The law is very clear. The prosecution cannot bring that up during the trial. Why? To prevent the judge from being prejudiced. The current case has to be judged on its own facts. Only after a person is found guilty can their past record be brought up, usually when the judge is deciding the sentence. And there you have it. We've walked the entire path, from a case getting sent up by a magistrate all the way to the final judgment. It's a journey filled with checks and balances and critical decision points. Which leaves us with one final thought. In this whole complex process, which single step do you think has the most power to shape the outcome? Is it the framing of the charge, the testimony of one key witness, or is it the power of the final arguments? Something to think about.